In the digital age, sharing information online feels incredibly easy. We upload, we link, we embed, we hit send on a file. It's just instantaneous. But often, the rules of copyright compliance feel like wading through this dense, confusing legal fog. We all interact with copyrighted material pretty much daily, right? Whether you're embedding a quick video clip into a presentation or maybe posting an article snippet in an online discussion, how do you know what you can actually use or link or even download without making a potentially costly mistake?
Yeah, that tension you describe between how fast we share digitally and the complexity of the legal protection, that's exactly what we're tackling today. We're doing a deep dive into some source materials that were actually designed to help compliance officers and educators navigate this exact landscape, specifically in the realm of online and, technology-enhanced courses. Our goal isn't just to define copyright, though. It's really to give you a critical, practical decision-making framework. And maybe shine a light on some specialized legal protections that, honestly, most people don't even realize exist.
Okay, perfect. Let's unpack this then. So our deep dive mission today is really focused on finding some clear pathways through that fog. We're going to clarify one fundamental, almost binary distinction that I think simplifies the whole legal calculus. Really understanding the difference between making a permanent copy of digital content versus just streaming it or linking to it. And then we'll explore the major specialized laws and open licenses, things like the Teach Acts and Creative Commons, that give you ethical, legal ways to use content that kind of skip the painful process of trying to justify traditional fair use. Right. So we have to start with the absolute foundation. What exactly is copyright? At its core, it's a form of protection grounded right in the U.S. Constitution and is granted by law for original works of authorship fixed in a tangible medium of expression. That last part, fixed in a tangible medium, that sounds pretty key.
It is key. And this is something many people overlook. But this protection is automatic. The sources we looked at confirm that copyright applies immediately to both published and unpublished works the moment they are fixed in that tangible form. So whether you email a rough draft to a colleague or, publish a finished novel, that protection exists from that moment. You don't need to file anything with the government. You don't even need to put that little A symbol on it for the basic protection to be active.
Okay, that's actually reassuring for creators.
Yeah.
But what about for users? If protection is automatic, how does content ever become free for us to use?
Well, protection is automatic, but it isn't infinite. That's the balance. It's intended to allow creators to benefit from their work for a certain period, but then eventually the work is meant to enter the public commons, for everyone. Copyright eventually expires. It's often a set period, like more than 70 years after the life of the creator in many cases. When that happens, the work enters the public domain. And we also have works that are just sort of born without copyright, things like certain U.S. federal government documents. Those are available immediately.
Okay, this is great. And this is where we get to a really helpful rule of thumb, something practical for quick decision making. If you're trying to quickly figure out if you can use something, the source material suggests remembering the 3 O's. If a piece of content hits one of these 3 markers, it's generally okay to use it freely.
Exactly. Think of this as your quick assessment tool, especially when you're, maybe putting course materials together quickly. The first O is official. This covers works created by the U.S. federal government. Generally, these are in the public domain. The second O is old. Works where the copyright has clearly expired. Usually that means the creator has been deceased for more than 70 years, but you do have to be a little cautious with very old materials because of some complex renewal rules from the past. But generally, old is good. And the third O is open. These are works where the creator has expressly given up some or all of their rights. Think about things like Wikipedia entries, which have multiple or corporate authors, or materials specifically labeled as Open Educational Resources, OER. Basically, if the creator voluntarily shares it with few restrictions, it's open. Okay, let's pivot now into the digital realm, because this is where the rules can feel a bit weird, but also where I think the biggest aha moment often happens for people. Just consider physical book for a second. If you want to read it, you must acquire a physical copy, right?
Right. Yeah, you have to buy it, borrow it, somehow possess it physically.
Exactly. But for digital content, that's not always the case. You can often consume a digital work, read an article, watch a video remotely without ever making a permanent copy of the underlying file onto your own device or server. This is the fundamental digital game changer.
Okay. And this is where those temporary copies, the cache copies, come into play, right? Like if I stream a YouTube video or read an article directly from a website, my computer or phone is definitely storing tiny temporary bits of that file just so it loads smoothly and plays without buffering. Are those temporary cache copies considered actual copies in the eyes of the law? Could I get in trouble for that?
Generally, no, and this is crucial. Thanks to specific provisions within the Digital Millennium Copyright Act, the DMCA, and also the TEACH Act, which we'll talk more about later. Those unintentional temporary cache copies are basically understood to be just an inherent part of how the technology works. They typically don't count as permanent, actionable copies that would violate copyright. This means you can serve up all kinds of content from their original locations on the internet as long as you use what the sources call a pass-through method, like embedding or linking.
Okay, so this is huge. Before we even get into the weeds of fair use, which, let's be honest, is notoriously subjective and feels legally risky, the first decisive question anyone using online content should ask is, have I actually made a copy? Meaning, did I download a separate permanent file that now lives on my hard drive or on my institution server or somewhere else totally separate from where it originally lives online?
That single question simplifies almost everything. If the answer is no, if you are just using a pass-through method like embedding a video player or linking to an article, then the sources are quite clear. Copyright law, in that instance, does not apply to your action of linking or embedding.
Wait, hold on a second, though. That sounds almost like a massive legal loophole. Are we really saying that if I just, say, embed a video from a website that clearly pirated a movie clip, as long as I don't download the file myself, just embed the player, I'm technically compliant? That doesn't feel right.
And you've hit the nail on the head there. That's the critical ethical consideration, the sniff test. Technically, yes, the law primarily focuses on the act of copying. But the sources strongly emphasize that while embedding or linking might be technically legal for you in that narrow sense, you absolutely have an ethical obligation. Knowingly linking to obviously unauthorized internet copies like that fan-uploaded movie clip instead of the official trailer from the distributor, that clearly fails the sniff test. You really are obliged to make a reasonable effort to ensure the linked content is being shared ethically by its owner or someone they've authorized. You can't just willfully ignore the source.
Okay, that makes much more sense. So the legal burden might shift from the act of copying, but an ethical burden regarding the source remains. So the best practice then, even when we're just linking or embedding, is probably always to use proper attribution statements. That way you document that you're using a pass-through method, and you also give the user, like a student, a citation link they can check if the original content ever breaks or disappears.
Precisely. Attribution in this context isn't just academic courtesy, it's smart documentation of your method.
Okay, so what if that no copy, just link or embed rule simply won't work for what you need to do? Maybe you need to modify the work, maybe crop an image, or you absolutely must have a locally hosted copy for, say, offline access or long-term stability. This is when fair use might not be enough or feels too risky, and you actually need permission or some kind of license, right?
That's exactly the next fork in the road. If your intended use goes beyond fair use or beyond simple linking, you need explicit permission. One route is seeking permission directly from the copyright owner. You find them, you ask, they hopefully say yes. If you get that permission, and this is critical, make sure you document it meticulously. Save the email exchange, get it in writing, maybe even upload that permission document to a secure permissions folder within your course management system. That documentation is your shield against any future claims.
Good advice. And before you even go through the hassle of tracking down an individual author or publisher who might be hard to find or unresponsive, you should always check with your institution first, right?
Absolutely. Always check your institutional licenses. Many universities and colleges, especially through their libraries, have negotiated broad licenses covering massive databases of films, journal articles, software, ebooks, you name it. It's entirely possible the material you need is already pre-cleared for use in your online course under one of these existing agreements. Definitely check the library resources first.
Okay. But let's say you do need individual permission, or you're looking at software or something with its own terms. You often run into these incredibly dense legal documents, the dreaded end-user license agreements, or EULAs. Has anyone actually read one of those from start to finish, or do we all just scroll straight to the bottom and click agree? It's overwhelming. And that seems to be why Creative Commons has become such a game changer.
Creative Commons, or CC, licenses really are the simplified, user-friendly option here. They are a form of open license. What they do is allow creators to selectively give up certain rights up front right when they share the work. This offers much more flexibility and clarity than trying to negotiate a unique permission or wading through a 50-page EULA. And the great thing is, most major search engines, Google Images, Flip YouTube, and content platforms now allow you to filter your searches specifically for CC licensed content. Makes finding usable stuff much easier.
Okay, let's quickly break down the 4 key building blocks, the designations that combine to form these CC licenses, because understanding these tells you exactly what you can and can't do with the work. The first one is attribution, or BY. This is pretty much the baseline for all CC licenses. You must credit the original author or licensor.
Right, that's non-negotiable. The second is non-commercial, or NC. This means the work can only be used for non-commercial purposes. So, for instance, you probably couldn't use an NC image in marketing materials for a course that students pay tuition for, not without seeking separate permission beyond the CC license.
Got it. Okay, the third one is no derivative works, or ND. This sounds quite restrictive. It means you can only share verbatim, exact copies of the work. No changes, no modifications, no adaptations allowed at all.
Correct. If it's ND, you can't translate it, you can't crop it, you can't remix it, use it as is or not at all. And finally, the fourth designation is share alike, or SA. This one is a really interesting mechanism for promoting openness. If you create a new work based on an SA licensed original-like, if you remix an SA song, you must license your new derivative work under the exact same share-alike license as the original. It basically ensures that derivative works also remain open and available for others to use and build upon under the same terms. It keeps the openness flowing.
That makes sense. So no derivative works means if you find a great Creative Commons photo, say of a historical map, you can't add your own annotations or color coding to it for your class if it has an ND license. You have to use it exactly as you found it. That clarifies the acronyms.
Exactly. And when you do make copies, even when you're allowed to under a permissive CC license, modeling ethical scholarly communication is still really important. The sources recommend using the acronym TASL as a model for a proper attribution statement. T stands for the title of the work. A is the author or owner who holds the rights. S is the site or original location of the work, ideally with a direct link. And L is the license or permission statement that grants you the right to use it, for example, license CC BY SA 4.0. Using TASL consistently helps others see you're following best practices. It clearly conveys the content isn't your own creation, and it models good attribution habits for students or colleagues.
Okay, we absolutely need to talk about one of the most significant pieces of legislation specifically for distance education in the U.S., the TEACH Act, the Technology, Education, and Copyright Harmonization Act of 2002. That sounds important. It seems like this was basically Congress acknowledging that online learning needed its own distinct set of copyright rules, different from a physical classroom. It came about because there was a need to modernize copyright law to allow certain uses of copyrighted material in digital distance without requiring an instructor to hunt down permission for every single item.
That's precisely right. It was intended as a major expansion of educators' rights beyond the four walls of the traditional face-to-face classroom. But, and this is a big but, to qualify for the protections offered under the TEACH Act, the eligibility criteria are actually quite strict, particularly for the institution itself. First, the institution must be an accredited nonprofit educational institution or a government body. For-profits don't qualify. And critically, the institution has to establish, publicize, and actively enforce a robust institutional copyright policy. They can't just ignore copyright issues.
And they also have to use technology to lock down the content, don't they? To make sure only enrolled students get access.
Absolutely crucial. The institution must use technological measures like password-protected course sites or secure logins. These measures have to reasonably prevent access and use by people who aren't enrolled in that specific class. And they also have to limit access to the materials primarily to the duration of the class session or the course term. If the content is just freely available on the open web, the TEACH Act protections generally won't apply to its use in the course.
Okay, so let's assume the institution meets all those requirements. What then is an instructor actually permitted to do under the TEACH Act? The sources say they can use material that's directly related to the course content and is part of mediated instructional activities, basically, part of the teaching process. They can use entire performances of things like non-dramatic literature or music, think reading a poem aloud or playing a full song. And they can use reasonable and limited portions of other types of works, like film clips or dramatic works. The Act also explicitly permits digitizing analog materials, like scanning a chapter from an old print book, but only for use within the system and for a limited time if a digital version isn't available.
Correct. But here's where we hit those really crucial limitations, the ones designed primarily to protect the commercial market for educational materials. This naturally raises the important question. What is specifically excluded from Teach Act protection? What can't you do?
Okay, number one seems big. You cannot use materials that are typically purchased or acquired by students themselves. This includes things like required textbooks, whether physical or digital, course packs, or materials traditionally placed on electronic reserves in the library. The Teach Act doesn't cover those.
That's the big one. And closely related, you also cannot use works that are specifically developed and marketed for the educational market for performance or display via digital networks. Think about, say, prepackaged online learning modules or digital simulations sold directly to schools for distance learning. The government decided to protect the publisher's business model for those kinds of materials. Furthermore, you must ensure the original copy you're using was legally obtained. You can't use the Teach Act to legitimize the use of a known pirated copy. And finally, students must be explicitly notified that the materials being used in the course may be subject to copyright protection. There needs to be a clear warning.
Okay, so we've spent quite a bit of time focused on protecting the content creator and, the commercial market for that content. But when we transition fully into these integrated digital course environments, there's another really significant legal and ethical hazard we need to consider: protecting the user. The student. We need to shift focus for a minute to the fine print involved in things like institutional digital access programs or those required digital textbooks where access is tied to course registration.
Yes, this is a massive and growing issue. Many modern online courses essentially require students to use specific digital textbooks or platforms, often through programs where the cost is included in tuition or fees. This means students are often required to click agree to the publisher's terms of service and privacy policies just to access their required course materials. And they often do this without really realizing the depth of the data tracking and usage that they might be consenting to.
Right. And the YOH system notice that was mentioned in our source materials really highlights a severe practical limitation here. It points out that while publishers often promise in their policies not to sell personal student information directly to unrelated third parties, the institution itself, the university or college, cannot actually guarantee the security of that student information once it's in the publisher's hands. And critically, those publisher privacy policies are subject to change, sometimes without much notice.
Exactly. And what this means, practically speaking, is that faculty and institutions really need to scrutinize these publisher policies much more closely. Publishers are often granted permission in that fine print to share personal student data, which is legally different from selling it, with various partners for purposes like research, analytics, product development, maybe even marketing. It's often broader than students realize.
So the call to action here for instructors, based on the sources, is really essential. Faculty are strongly encouraged not only to investigate these terms themselves, but critically, they should include a clear notice right in their syllabus. This notice should remind students to actually read the publisher's privacy policies carefully. And students must always be informed that they usually have the option to opt out of these digital platforms and their associated tracking and access the required course materials in alternative formats, even if that means getting a slightly less convenient physical copy. The choice needs to be clear.
So we've covered quite a bit today. We talked about the automatic nature of copyright, how it just springs into existence. We really emphasized the importance of that no copy rule in the digital space, the linking and embedding distinction. We explored the flexibility offered by Creative Commons licenses as an alternative to traditional permissions. And we dug into the specific permissions, but also the significant limitations granted by the Teach Act for distance education. Ultimately, knowledge of these frameworks is, well, it's most valuable when it's clearly understood and then actively applied in practice.
Absolutely. So what does this all mean for you listening right now as you navigate the internet tomorrow, maybe preparing a presentation or posting online? I think the key takeaway is that navigating digital content usage starts not with trying to memorize dense law books, but really with one simple, actionable question. Have you made a permanent copy? If the answer is no, then embedding and linking become your primary, easiest, and most flexible solutions provided, and this is crucial, that you also pass that ethical sniff test. Quote, You need to make sure the content you're linking to is being shared legitimately by an authorized source.
And thinking about those limitations, especially within the TEACH Act, raises a really important, maybe even provocative question for the future of education. Given the very strict limitations built into the TEACH Act, specifically how it prohibits using materials traditionally purchased by students, like textbooks, how do institutions effectively balance that strong drive we see for comprehensive, engaging, digitally supported distance learning with the equally strong statutory protection that exists for the commercial market for educational materials? It's a fundamental tension, isn't it, between pedagogical goals and market protection. Something worth mulling over the next time you log into an online course or platform.